All right. This is the third subsection of Section 7, which is all about arrests and use of force. So, an arrest is a seizure for purposes of the Fourth Amendment. So, the Fourth Amendment says you should be protected against unreasonable searches and seizures. Well, an arrest is a seizure. When can police arrest you? Well, they can arrest you for any crime in their presence. If you violate the law and a police officer saw you do it, they can arrest you for it. They can arrest you for any felony crime if they have enough probable cause to believe you did commit it or are committing it. So, if they are investigating, they find this piece of evidence and this piece of evidence. Oh man, together we've got enough probable cause to believe you committed a felony crime. You get arrested, even if they didn't actually witness you doing it. And then finally, you can arrest someone with an arrest warrant. Okay, so a judge has signed an arrest warrant for Bob Smith. If I see Bob Smith out and about, I can be like, hey, Bob Smith, there's a warrant for your arrest. Put him in handcuffs. You can only go out and, if I have an arrest warrant in hand and it's like, okay, I've got this arrest warrant for Bob Smith, I'm going to purposefully go out here and try to arrest Bob Smith. That can usually only be done during the day. It's called a nightcap. And you can get that overruled by a judge. So if there's some reason why you want to arrest the person at night, you can go to a judge and say, Judge, I would really like to serve this arrest warrant at night for this reason and this reason and this reason. And the judge can give that an exception to that rule in the warrant, but it has to be positively asked for and given by the judge. If it's not actually sought for, you can only serve that arrest warrant at night. Now, if police are interacting with a citizen at night for some other reason, they get pulled over for traffic stop or whatever at midnight, and they have an arrest warrant, you can serve the arrest warrant then, but you weren't actually going out to find that person to serve the arrest warrant. They just happened to show up right there at night, which is a different thing. Interesting case here, which came out, I think this one was from right near where I lived when I was growing up, Atwater v. Lago Vista. Police can arrest you even if the maximum penalty for the crime they arrested you for is a fine. You can still be arrested and booked even if the only crime they have to arrest you for is one that's not punishable by any jail time. And this almost never happens. This is an incredibly rare occurrence, but I can't remember the exact facts of this case, but there was some reason why the officer wanted to arrest this person and actually take them down to jail and book them, even though the only crime the officer could arrest the person for was something with where the maximum penalty was a fine. And if you're going to arrest somebody for a felony based on probable cause, you have to have the probable cause ready before you arrest them. You can't arrest somebody and then gather enough probable cause to justify the arrest. The probable cause has to exist prior to the actual arrest happening. Okay? Miranda rights, remember, you got to read Miranda rights after you arrest someone and they're no longer detained, no longer free to leave, and before you question them about a crime. But after you arrest them and before you read the Miranda, or even after you read the Miranda, if they invoke their right to a lawyer, right to remain silent, you can still ask them questions about non-crime things, right? So if I arrest somebody for arson, either before I read them in the Miranda rights or I've read them in the Miranda rights and they have said, I'm choosing to remain silent, I want a lawyer, I can still ask them questions, just not about a crime. So if I want to say I arrest them and they're in bare feet, I can ask them, hey, do you want me to go inside and grab you a pair of shoes? Because that has nothing to do with the crime, right? So I'm still allowed to ask them questions, just not question them about the crime they're being arrested for. There's also such thing as a de facto arrest, where police officers in the past have tried to say, look, you got to come with us down to the station. You're not free to leave. We're going to put you in handcuffs, take you down to the police station, but it's not technically an arrest. So we don't have to treat you like you're under arrest. We don't have to read you your Miranda rights and everything. And what the Supreme Court has said on that one is, nah, you can't do that. If it walks like a duck and quacks like a duck, it's a duck. A lot of court cases coming up. Prepare yourself, because there have been court case after court case after court case about what's allowed with arrests and what isn't. So here we go. First of a couple slides worth of court cases. Maryland v. Pringle, 2003. In this case, an officer pulled over a car. There were 3 occupants. They searched the car and found drugs. None of the 3 would admit to the drugs being theirs, so the officer arrested all 3 of them. Went to the Supreme Court because the people said, he didn't have probable cause to arrest all 3 of us. He only had enough probable cause to arrest whoever's drugs they were, and they weren't drugs belonging to all 3 of us. And the Supreme Court said, no, bad argument. If the police officer finds drugs in the car, they're allowed to arrest whoever they think might have owned those drugs. They don't have to narrow it down to just one person before they make an arrest. Illinois v. Wardlow, 2000. If, in this case, officer was either walking or driving, and a person saw, oh my God, that's a police officer, turned around and ran away. And the officer used that as the reasonable suspicion to conduct a Terry stop. And remember, a Terry stop is named after Terry v. Ohio, where they're detaining a person without probable cause. All you need is reasonable suspicion to detain someone for purposes of investigating whether a crime has happened. And seeing a police officer and turning around and running the other way counts as reasonable suspicion. Hibble v. 6th District of Nevada, 2004. This is kind of a weird one. So in states, there are some states, and I think it's roughly half of them, that have a state law that says if you're stopped by police under that reasonable suspicion standard from Illinois v. Wardlow and Terry v. Ohio, that same reasonable suspicion level, police have detained you for an investigation. In roughly half the states, there's a state law that says police are allowed to require you to identify yourself. And the easiest way to do this is with a driver's license or something, but if you don't have a driver's license, they're allowed to kind of use other investigative techniques, including fingerprinting, in order to determine who you really are. And you're not allowed to plead self-incrimination for being forced to identify yourself. And the Supreme Court in this case said that's constitutional, that's okay, that doesn't count as self-incrimination. So that doesn't mean it's legal everywhere in the United States. It just means if your state has that law on the books, that is doesn't violate your constitutional rights. So you can look up right now, if you're living in the United States, you can look up what state you're in and whether they have one of those laws to figure out whether you have to identify yourself to police during one of these reasonable suspicion Terry stops. And the last one on this slide, Pearson v. Ray, 1967. This was about false arrest. So sometimes police think you committed a crime, and they turn out, oh, you didn't actually commit that crime. What matters isn't the ultimate truth that they figure out in hindsight. All that matters is what a reasonable officer would have believed based on what they knew at the time they arrested you. So would a reasonable officer have believed that there was probable cause to arrest you when they arrested you? The answer is yes. That wasn't a false arrest. They can't be held liable for it, even if it turns out they were wrong. If a reasonable officer wouldn't believe that there was actual probable cause to arrest you at the time that officer arrested you, then that can be tried as a false arrest, and the officer can face both civil or, less commonly, criminal penalties for that. Now, there's a three court case series which is all about arrests outside the home that all have to do with search incident to arrest. So, as you probably know from other videos on this channel, when police arrest someone, they can do what's called a search incident to arrest without a warrant. You don't need a warrant to search somebody if you're arresting them. And as part of that search incident to arrest, they can search you, any containers on you, like a purse or a backpack, excuse me, and anything within your immediate area. And that immediate area thing has been fairly widely interpreted in the past, but in these three cases, the Supreme Court really narrowed it down. So in the first one, James v. Louisiana in 1965, police arrested someone 2 blocks away from their house and then took them to their house and searched their house as a search incident to arrest. Supreme Court says no, 2 blocks away is not in their immediate area. That's ridiculous. Second one, Shipley v. California, just a couple years later. Similar thing, guy gets arrested getting into a car in his driveway. Police arrest him in his car in his driveway, and then take him inside his house and search his house as a search incident to arrest. And the Supreme Court again says, no, that is not incident to arrest. The inside of his house is not within his immediate area if he's in his driveway. And then the third one in the series, Vail v. Louisiana, just the next year. He was arrested on his front porch. Police arrest him and they say, as search incident to arrest, we're going to go inside your house and search. And again, the Supreme Court said no. Even if you arrest him on the front porch, the inside of his house doesn't count as his immediate area. You can't use search incident to arrest to justify that. And then the last kind of major subject we're going to talk about in this section is use of force. Use of force is a very misunderstood thing. There's lots of people that, lots of myths about what police are allowed to do and what police are not allowed to do. So, if police have probable cause to arrest you, and they say you're under arrest, at that point, they can use any force that is reasonable in order to effect that arrest. So again, they have to have that probable cause. If a reasonable officer wouldn't believe that there was probable cause to arrest you, it's a false arrest. They can't use any force at all. But if a reasonable police officer would believe they have the probable cause to arrest you, and you resist, you don't want to get arrested, they can use whatever force is reasonable to do that. And what force is reasonable to do that depends on your actions. It depends on the environment. Does the officer have backup or not? Do you have friends around or not? So there's lots of different kind of situational factors that can change what's reasonable and what's not reasonable. In some cases, they can strike you. They can use a baton or electronic control device, or pepper spray, or temporary chokeholds. There's all kinds of things that officers could theoretically use in a reasonable way, depending on the specific facts of that situation. And in other cases, those things that are perfectly legal in some situations would be way more a force than is reasonable in other situations. So if I'm being arrested and I just kind of jerk my hand away, but then, make no other move to resist, a police officer, it wouldn't be reasonable for a police officer to pull out his pepper spray and spray me in the face at that point, right? That's not a reasonable use of force when all I'm doing is literally like moving my wrist 6 inches. But if I punch the police officer in the face, they can punch me back, right? That's reasonable force. If I'm using a punch against them, they can use a punch against me. The good news is, use of force, even the threatened use of force, is incredibly rare. There was one survey that said there's only threatened use of force or actual use of force in 1.4% of all police-citizen interactions. So it's incredibly rare even to threaten force, let alone use it. But if there is excessive force used, again, police can face both criminal and civil penalties for that. So you want to make sure if you're a police officer, if you're an investigator, only use the force that is reasonable. Graham v. Connor, 1989. This is kind of the controlling Supreme Court case about police use of force. And this is just, this one sentence summary of the conclusion does not do this case justice. This is a huge, really incredibly important case from a legal perspective. But one of the many things that is important about this case is it says that force is reasonable or not reasonable, not with hindsight, but only with what the officer knew at the time. So if what the officer reasonably believed at the time later turned out to be false, that doesn't change whether the force used at the time was reasonable or not reasonable. All that matters is what a reasonable officer would believe at the time the action happened. We can't judge that action based on the hindsight that comes with time after that. There's two kinds of, when you're talking about police and use of force, there's essentially two different kinds. There's deadly force, and then there's what's been kind of recently changed to being called less than lethal force. It used to be commonly called non-lethal force, but we don't use that term anymore because it's technically not non-lethal, it's just less lethal or less than lethal. And this can include everything from restraints, which most commonly means handcuffs, but there's also a lot of officers that use plastic flex cuffs or other kind of restraints. There's aerosols, pepper spray. What's the other one? It's pepper spray and tear gas. And I've been around tear gas, and it is no party. I mean, it is horrible. The pain in your face is really extreme. You do not want to get hit by that stuff. There's impact weapons. This includes the baton, but it also includes things like beanbag rounds from a shotgun, which you can see right there. They use special shotguns that are usually bright plastic stock that shoot these rounds that they fly very fast and they hit very hard and they hurt really bad, but the odds of them actually causing any kind of permanent injury, let alone death, are incredibly low. So in that way, you can really hurt somebody with a very minimal chance of either permanent injury or death. And then there's electronic control weapons or electronic control devices, and one of the brand names of that is the taser, right? We've all heard of the taser. But that's a brand name. It's technically, you're supposed to call them by the generic name, electronic control weapon or electronic control device. But those override the signal from the brain to the muscles. So even if you want to move, you can't because the electricity is kind of making all your muscles fire at once. It's very, very painful, but it has essentially a 0% chance of doing any kind of real damage. And when there is damage done, the vast majority of the time, it's because the prongs that go in you, essentially the taser shoots out two little metal prongs, and if both of those touch you, and usually they pierce your skin, but if they both touch you, it sends that electronic current that makes your whole body go so you can't move. And the vast majority of all injuries from a taser are when those two piercy things, maybe they hit somebody in the eye, or they hit a vulnerable spot and it, maybe becomes infected, but it's essentially like a fish hook, right? It hurts and it can cause damage if it hits you in exactly the wrong spot, but it's not really that dangerous. And the electricity itself is essentially harmless long term. They've done millions and millions of these taser shocks, training police officers. And I don't think there's ever been a recorded case in training of anybody suffering any negative long-term effects from that electric shock. And then there are other ways to use force. There's other tools that police have to use force, but these are the common ones. Deadly force. Deadly force is obviously the most serious kind of force. The most common way to use deadly force for police is, of course, their firearms. Most commonly pistols, which is what police officers normally carry, but also there are some occasions where police will use actual shotguns or rifles. Um, and essentially, what the standard is for using deadly force is there has to be an imminent threat of death or great bodily injury to either the officer or some third person, right? So it's not enough for there to be some kind of theoretical threat. And that changed in 1985 in the case of Tennessee versus Garner. So prior to this case, there were a lot of states where they said if police have probable cause to believe that this person is a felon and that person is fleeing from the police officer because there's this kind of threat or hypothetical threat that this fleeing felon could later go on to hurt somebody, that was enough to justify deadly force. And in Tennessee versus Garner, they said, no. That hypothetical threat isn't enough. You need an imminent threat, right? So if somebody's charging at an officer with a knife, that's an imminent threat. If somebody says, I'm going to come back later and punch you in the face, that's a threat, but it's not really imminent, right? So it has to be an imminent, happening right now threat of either death or great bodily injury to the officer or some innocent other party. And then police are allowed to use this deadly force. And that doesn't just include guns. That can include a car. It can use any tool, whether it's a gun or a car, fire, flamethrower, whatever. That is kind of reasonably expected to cause death. One of the difficult issues with the use of force is mentally ill people. There's a lot of mentally ill people in the United States. There was one survey that said 4.1% had a major mental illness episode within the past year. That's a lot of people that have these mental crises, and they need help. And a lot of times, the police are not the right people to go deal with these people. They're the only people we got. So unfortunately, even though it shouldn't be their job, it is their job. So a lot of police departments have hired either specially trained officers and created crisis intervention teams, which are specifically trained to deal with mentally ill people and to not let it escalate and to not kind of make the problem worse, but they've been specially trained to find these people with mental illness, approach them, create a rapport, and kind of end whatever crisis situation these people are in, which depends on what kind of mental illness and their situation and all these things. Some police departments are even finding that the kind of more cost-effective approach is just to hire non-officers to go on these calls. So there are a lot of police departments, especially in the last year or two as I'm recording this, that have found that these kind of calls, the certain kind of call, they don't need to send an actual police officer. They can send somebody whose entire job it is to deal with things like this. And it's cheaper for the police department. There's way less chance of anybody getting hurt. There's a lot more successful interactions and helping people with mental illness and people going through these kind of crises. But the absolute worst situation a cop can face, arguably, is somebody who wants to commit what's called suicide by cop, where basically these people want to die, they want to commit suicide, but for one reason or another, they don't want to be the one to do it themselves. So what they do is they kind of induce a police officer to kill them as a form of suicide. And it's a lot more common than most people seem to think. And it's a very, very mentally and emotionally harmful to the officer that gets kind of thrust into that situation. Because no officer, or I shouldn't say, the vast, 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 vast majority of officers don't want to kill anybody. They don't want to have to use their guns at any point in their career. But so when somebody comes out and kind of forces an officer to do that, it can be very psychologically and emotionally hurtful to that officer. So the point is, when we're dealing with people who are mentally ill, we really want to make sure and get them the help they need. We want to de-escalate. We want to deal with their issues as mental health issues and not as threats. And the good news is there's kind of a national conversation that I hope is just beginning as I'm recording this, about how do we help the police focus on the crimes that are their job and that they should be focusing on, and leaving the things like mentally ill people in crisis to someone else who's not a police officer, or at the very least a police officer who's been specially trained to go out and better deal with that situation than just an everyday patrol officer who hasn't been trained or prepared to do that specific job. At any rate, that's the end of Section 7. Thank you so much for watching. I'll see you in Section 8.